Good afternoon, class. Today, we will be discussing the legislative branch. Kindly watch this video and make your realization about it.
Legislative power is defined as the power to propose, enact, amend and repeal laws or statutes. In simple terms, it is the power to create or make laws of the Philippines. It is the process of lawmaking. It is the Philippine Congress that exercises that prerogative. Article 6, Section 1 of the Constitution states that the legislative power shall be vested in the Congress of the Philippines, which shall consist of a Senate and a House of Representatives, except to the extent reserved to the people by the provision on initiative and referendum. Provision clearly states that legislation could take two forms. First is through Congress, second is through the people themselves. There are instances that people are given the opportunity to enact laws, both national and local setting. Section 32, Article 6 of the Constitution provides that the Congress shall as early as possible provide for a system of initiative and referendum, and exceptions therefrom whereby the people can directly propose and enact laws or approve or reject any act or law or part thereof passed by the Congress or local legislative body after the registration of a petition, therefore signed by at least 10% room of the total number of registered voters, of which every legislative district must be represented by at least 3% room of the registered voters thereof. Philippine Congress, complying with the mandate of this provision, enacted Republic Act No. 6735, an act providing for a system of initiative and referendum. Initiative is the power of the people to propose amendments to the Constitution or to propose legislation in an election called for that purpose. It can also be exercised on the local level through the proposal of the people or ordinances in their respective local government units. Referendum is the prerequisite of the electorate to approve or reject proposed law, both national and local setting. We have two kinds of legislative power. First is the original legislative power. It is the power of the sovereign people to enact laws. Second is the derivative legislative power. It is the power to enact laws delegated by the sovereign people to their elected representative, which is of course the Philippine Congress. Legislative power can be classified as ordinary and constituents. Ordinary legislative power is the power to legislate ordinary laws or statutes. Second is the constituent legislative power is the power to amend or revise the Constitution. Limitations to legislative power are substantive limitation. It pertains to the content of the law itself. Any law legislated by Congress must not contravene any constitutional doctrine, otherwise it will be declared as invalid and may not have any legal effect. It must also be stressed that laws legislated by Congress must be reasonable and capricious in nature, or else it could violate the due process clause in the Constitution. Next is the procedural limitation. It outlines the manner on how the law was passed. There are constitutional provisions and laws to be observed in lawmaking in order for any statute to be procedurally valid. Philippine Congress is the seat of legislative power in the Philippines. It is tasked to legislate on the statutes that will provide for the social entering of the entire society. It is a bicameral Congress which is composed of the upper house, the Philippine Senate, and the lower house, the House of the Representatives. The Philippine Congress is a bicameral Congress, which means it is composed of two houses, as opposed to unicameral Congress, which is merely composed of a single house. Philippine Senate is the upper house of the Philippine Congress. It is composed of senators who are elected by the entire voting population of the Philippines. The term of office of the senators shall be 6 years and he can be re-elected for not more than 2 consecutive terms.
So now let's proceed to the House of Representatives. So the House of Representatives is the lowest house of the Philippine bicameral Congress. So when we say bicameral Congress, it pertains to two separate houses, or also what we call legislative chambers. In the lower house, it has the greater number compared to the 24 senators. By the time in 1987 Constitution became operational, so in general, there are 250 representatives. The Constitution provides that ang kapulungan ng kinatawan ay bubuin ng hindi higit sa 250 members, maliban na lamang kung itatakda ng batas ang dapat ihalal mula sa distriktong pambatas na hinati-hati nga sa mga lalawigang lungsod gaya ng cities, probinsya at metropolitan. So sa lugar ng Manila, gaya ng sa bilang ng kani-kanilang mga naninirahan at sa pagkakapare-pareho ng tinatandang batas ay dapat ihalal sa pamamagitan ng party list system. The second one is, sinasabi dyan na ang kinatawan ng party list ay dapat bubuo ng 20% na kabuuan bilang ng mga kinatawan kabilang ang mga nasa ilalim ng party list para sa tatlong magkakasunod na termino pagkatapos ng ratifikasyon ng Constitution. Kalahati ng mga pwestong inilaan sa mga kinatawan na party list ay dapat punan ayon sa itinatadhana ng batas sa pamamagitan ng pagpili o halalan mula sa na ang mismo pong pipili or maghahalal sa kanila ay ang katutubong pamayanan, kultural na kababaihan, kabataan, at ang mga maralita, at iba pang sektor na maaaring itadhana ang batas. So dito naman po sinasabi ay ang bawat distritong pambatas ay dapat bubuuin hanggat magagawa ang nakakahawang compact at karating territory, o bawat lungsod na may populasyon na hindi bababa sa 250,000, o bawat lalawigan ay dapat magkaroon ng hindi bababa sa isang kinatawan. Sila ay ihahalal mula sa mga distritong lehislatibo na hinati-hati sa mga lalawigang lungsod at metropolitan na lugar ng Manila at alinsunod sa kanilang mga naninirahan at batay sa kapare-pareho at progresibong ratio ng kanilang kinatawan. Ito ay binubuo din po ng mas malaking dami ng kasapian sa mababang kapulungan nila. So nagmula din ito sa iba't ibang distritong pambatas sa mga lungsod ng lalawigan at metropol. Ang mga kinatawan na ito ay bubuo ng 20% ng kabuuang bilang ng mga miyembro sa pamamagitan po ng party list system ng mga rehistrasadong pambansang regional o sektoral na partido. Ganun po. Para naman po sa tatlong magkakasunod-sunod na termino, pagkatapos ng ratio ng Constitution po ay kalahati ng mga pwesto ay matatagpuan sa kinatawan ng party list. Ito ay dapat punan ayon sa itinatadhanang batas sa pamamagitan po ng pagpili mula po sa labor, peace, at urban poor, indigenous, and cultural communities po. Ang mga kinatawan na ito ay dapat bubuin ng mga nahalal mula sa iba't ibang sektor. Ang batas ay lalampas or dadaan muna siya sa Pangulo. Ito ay maaari niyang punan ang appointment mula sa listahan ng mga nomination na kani-kanilang sektor at ang mga pwestong nakalaan po para sa sektoral na representasyon. So now we are going to tackle about the qualifications for membership in the lower house. In Article 6, Section 6 provides for the qualification of the member of the House of Representatives. Most of the requirements for membership in the Senate are almost the same with the membership in the House of Representatives, but of course with a slight modification as to the residency and the registration requirements. It should also be observed that party list representation are not required to be able to read and write. The reason for this is obvious, right? So the first one is natural-born Filipino citizen. So just like in citizenship requirement for senators, members for the House must be natural-born Filipino citizen. And then the second one is they should be 25 years of age on the day of the election. So the representative must be at least 25 years of age on the day of the election, but the filling in the certificate of the candidacy. And then the third one is the know or able to read and write. So the literacy requirements for members of the House Representative is the date. He is qualified. Pag marunong ka po magbasa at magsulat, qualified ka to run as a representative. Registered voter ka. And then the fifth one is resident of the district which he shall be elected for not less than 1 year immediately preceding the day of the election.
Let's talk about the party list system. Republic Act Number 7141, it defines the party list system as proportional representation mechanism in the election of representative to the House of Representatives from registered, national, regional, and sectoral parties, organization, there with the Commission on Election (COMELEC). As a result, a voter can choose between the two types of representative. A district representative, it representing a city, district, municipality, or the province for his legislative district, and the party list group, which has no geographical limitation. So ayon sa Republic Act 7941, ang saysay ng pagkakaroon ng ganitong sistema sa Kongreso ay para mapagbigyan ang mga kinatawan mula sa mga marginalized at underrepresented na sektor sa paggawa ng mga batas nang sa gayon ay matugunan ang mga pangailangan ng mga nasabing sektor. One is the national and regional parties organization are not required to organize along sectoral lines. Political parties that run candidates in legislative district election are only allowed to run in party list election through their sectoral wing which must register separately under the party list system. Sectoral parties or the organization may either be marginalized and underrepresented, lacking in political constituencies. The sectors that lack include professionals, the elderly women, and the youth. National, regional, and sectoral parties or organizations are not disqualified if some of their nominees are disqualified as long as they have at least one qualified nominee. In manifestation of party list, it's very important that you already file your candidacy before 90 days of election. It is one of the rules and guidelines so that the candidate must follow these rules. Manifestation is something that your willingness to be part of the party list. The state shall develop and maintain a full, free, and open party system in order to achieve the broadest possible representation of party, sectoral, or group interests in the House of Representatives by increasing their electoral chances. Let's move to registration. Any organized group of persons may register as a party, organization, or the coalition for purposes of the party list system by filing with the COMELEC not later than 90 days before the election a petition verified by its president or secretary stating its desire to participate in the party list system as national, regional, or sectoral party, or the coalition of such parties, organization, attaching their constitution by laws, platform or program of the government, list officers, coalition agreement, and other relevant information.
After due notice and hearing. So, registration of any national, regional, sectoral organization or coalition on any of the following grounds. So, number 1, it is a religious sect or denomination, organization or association organized for religious purposes. Number 2, it advocates violence or unlawful means to seek its goal. Number 3, it's a foreign party or organization. Number 4, it's receiving support from any government, foreign political party, foundation, organization, whether directly or indirectly through third parties for partisan election purposes. And also, COMELEC reviews and cancel the registration when it violates or fails to comply the laws, rules, or regulation relating to elections. It declares untruthful statement in its petition. And lastly, it has ceased to exist for at least 1 year, or it fails to participate in the last 2 preceding elections, or fails to obtain at least 2% of the votes cast under the party list system in the 2 preceding elections for the constituency in which it has registered. Qualification of party list nominees. No person shall be nominated as party list representative unless he is a natural born citizen in the Philippines, and also he or she registered voter, able to read and write, and also he must at least 25 years old and not more than 30 years old of age the day of election. Manner of voting. Every voter shall be entitled to 2 votes. Ang una ay para sa mga miyembro ng House of Representatives in his legislative district. At ang second na boto naman ay para sa partido or organisasyon na he wants to represented. And the COMELEC shall undertake the necessary information campaign for purposes of educating the electorate on the matter of party list system, in determining the allocation of votes for the second. The following procedure shall be observed. A. The parties, organization, and coalitions shall be ranked from the highest to lowest, based on the number of votes they garnered during the elections. B. The parties, organizations, and coalitions receiving at least 2% of the total vote cast for the party system shall be entitled to a seat each, provided that those garnering more than 2% of the votes shall be entitled to additional seats in proportion to their total number of votes. So finally, that each party, organization, or coalition shall be entitled to not more than 3 seats. The purposes of May 1988 elections, the major 5 political parties, on the basis of party representation in the House of Representatives, shall not be entitled to participate in the party list system. Procedure in allocation proportionately according to the percentage of votes obtained by each party. So, organization or coalition as against the total nationwide votes cast for the party list system.
How party list representatives are chosen? Party list representative shall be proclaimed by the Comelec based on the list of the names submitted by the respective parties, organization, or coalition to Comelec according to their ranking in said list. In choosing the name of the party list representative, the Comelec will announce based on what the respective parties or organizations have submitted in the Comelec according to their ranking set about the names of the selected party list representative. The next is the term of office. Party list representative shall be elected for a term for 3 years, which shall begin unless otherwise provided by law. And at the noon on the 30th day of June, next following their election, no party list representatives shall serve for more than 3 consecutive terms. Voluntary renunciation of the office for the any length of the time shall not be considered as an interruption in the continuity his service for the full term for which he was elected. So, sa term of office or termino ng panunungkulan, nakapaloob dito na ang kinitawan ng party list ay dapat ihalal para sa isang termino ng 3 taon na magsisimula. At sa ika-30 araw ng Hunyo, kasunod ng kanilang halalan, walang kinatawan na party list ang dapat maglingkod ng higit sa 3 taon na magkasunod na termino. At ang voluntaryong pagtalikod sa katungkulan sa anumang haba ng panahon ay hindi dapat ituring na pag-aantala sa pagpapatuloy ng kanyang paglilingkod para sa buong termino kung saan siya inhalal. And then next is change of affiliation and effect. An elected party list representative who changes his political party or sectoral affiliation during his term of office shall forfeit his seat, provided that if he changes his political party or sectoral affiliation within 6 months before an election, he shall not be eligible for nomination as party list representative under his new party or organization. So, dito naman nakapaloob na kung sino man ang nahalal na kinatawan ng party list na nagpapalit ng kanyang partido pampolitika o sektoral na kaanib sa panahon ng kanyang panunungkulan ay mawawala ng kanyang pwesto. At sa kondisyon kung siya ay magpalit ng kanyang partidong pampolitika o sektoral na kaanib sa loob ng 6 na buwan bago ang isang halalan, siya ay dapat at hindi karapat-dapat na manominasyon para sa party list sa ilalim ng kanyang bagong partido or organisasyon. The next is vacancy. In case of vacancy, in the seats reserved for party list representative, the vacancy shall be automatically filled by the next representative from the list of nominees in the order submitted to the Comelec by the same party, organization, or coalition who shall serve for the unexpired term. If the list is exhausted, the party, organization, coalition concerned shall be submit additional nominees. Dito naman sa vacancy, kung sakaling mabakante ang mga pwesto na nakalaan para sa mga kinatawan ng party list, ang bakante ay automatikong pupunan o pabalitan ng mga susunod na kinatawan mula sa listahan ng mga nominado sa kautosan ng Comelec na kapareho ng partido din.
Good day everyone! I will tackle all about the Electoral Tribunal and Commission of Appointments. The Electoral Tribunal, both the Senate and the House of Representatives, shall each have an Electoral Tribunal. So what is the Electoral Tribunal? Electoral Tribunal is the sole judge of all contests relating to the election returns and qualifications of all its members. So how does this work? For instance, when a defeated candidate challenges take note, furthermore, a case passes from the COMELEC to the Electoral Tribunal when there is already a proclaimed winner. He or she has taken his or her oath and he or she assumed office as a member of the House of Representatives or the Senate. There are actually the Electoral Tribunal, the Presidential Electoral, the Senate Electoral, and the House of Representatives. Each electoral tribunal is composed of 9 members, 3 of which are justices from the Supreme Court to be designated by the Chief Justice. Remaining shall be either from the Senate or the House of Representatives. As the case may, they shall be elected on the basis of proportional representation from the political parties or organizations registered under the party. The system of the chairman of the electoral tribunal shall be the senior justice. So, next is the Commission of Appointments. So, what is the function of the Commission of Appointments? It acts as a legislative check on the appointing authority of the President, how for the appointments made by the President to be valid, the consent or approval of the mission of appointment is necessary. An exception, however, it is that the Vice President may be appointed as a member of the Cabinet without the need for the approval of the Commission of Appointments. So, according to Constitution, a commission shall be compared of the Senate President or its ex officio chairman, who shall not vote unless there is a tie. There should also be 12 senators and 12 members of the House of Representatives elected on the basis of proportional representation from the political parties or organizations registered under the party list system. The Constitution gives to the 2 houses of Congress the primary jurisdiction to decide who should sit in the Commission of Appointments. You shall act on all appointments given to it within 30 sessions of Congress from their submission. This is to prevent a commission from freezing appointment. Your ruling should be based on the majority vote of all its members. So take note, however, that the Commission of Appointments shall meet only while the Congress is in session. Open a call of his majority of all its members. The Electoral Tribunal and the Commission of Appointments shall be constituted within 30 days after the Senate President and the Speaker of the House of Representatives has been elected.
Privileges enjoyed by the members of Congress. The Philippine Congress due to its indispensable significance to governance and the promotion of public welfare through legislation, the Constitution has vested it with special privilege that can only be enjoyed by the members of the Senate and the House of Representatives. Immunity from arrest. Article 6 states that a senator or a member of the House of Representatives shall, in all offenses punishable by not more than 6 years imprisonment, be privileged from arrest while the Congress is in session. The primary arguments of the movement is the mandate of sovereign will. He states that the sovereign electorate of the 1st District of Zamboanga del Norte choose him as their representative in Congress. Having been re-elected by his constituent, he has the duty to perform the function of a congressman. He calls this as convenient with his constituent, made possible by the intervention of the state. He adds that it cannot be defeated by insuperable procedural restraint arising from pending criminal cases. The immunity from arrest or detention of senators and members of the House of Representatives, the latter customarily addressed as congressmen, arises from a provision of the Constitution. The history of the provision shows that privilege has been granted in a restrictive sense, the provision granting an exemption as a special privilege cannot be extended beyond the ordinary meaning of its term. It may be not extended by intendment, implication, or equitable consideration. For offenses punishable by more than 6 years imprisonment, there was no immunity from arrest. The restrictive interpretation of immunity and intent to confine it within carefully defined parameter is illustrated by the concluding portion of the provision, to wit, that the Batasang Pambansa shall surrender the member involved the custody of the law within 24 hours after its adjournment, or recess for its next session. Otherwise, such privilege shall cease upon its failure to do so. The present Constitution adheres to the same restrictive rules, minus the obligation of the Congress to surrender the subject congressman to the custody of the law. The requirement that he should be attending session or committee meeting has also been removed. For relatively minor offenses, it is enough that Congress is in session. Sabi nating immunity to arrest, ito yung maaaring maporsahan ng isang congressman or senator sa kasong binabato sa kanya while he or she is on session. So it means kahit nakakulong siya, is yung obligation niya as a senator or congressman is to be tuloy, just like what happened in Senator Laila Villarreal. Privilege of speech and of debate. Members of the Philippine Congress enjoy the privilege of speech and debate. The rationale for this privilege is the nature of deliberative assembly, such as the Congress. Senators and members of the House in the course of their duty to legislate may engage in the heated debate or discussion with the fellow members of Congress, which could be resolved in a barrage of unpleasant words. Members of Congress are also given an opportunity to deliver their privileged speech before the chamber where they belong to address issues and controversies designing the nation that can be subject of legislation. In the aforementioned instances, congressmen and senators alike are given the full freedom to speak their mind in order to cultivate the atmosphere for free discussion, which is very much necessary for lawmaking. Restraint in speech and discussion is not helpful in bringing up timely legislation. The Constitution provides for the salaries of the members of the Congress. It states that the salary of a senator and a member of the House of Representatives shall be determined by law. No increase in said compensation shall take effect until the expiration of a full term of all the members of the Senate and the House of Representatives approving such increase. This rule guarantees that the members of the Congress will simply increase their salaries and emoluments during their term of office. Qualification to hold other public office. The pertinent provision in this matter is no senator or member of the House of Representatives may hold any other office or employment in the government or any subdivision, agency,
contract with or in any franchise or specialized privilege granted by government or any subdivision, agency, or instrumentality thereof, including any government-owned or controlled corporation or its subsidiary during his term of office. He shall not intervene in any matter before any office of the government for his pecuniary benefit or where he may be called upon to act on account of his office. The first provision is the prohibition to personally appear as counsel before courts. The second one is to engage directly or indirectly to any contract entered into by any instrumentality of the government. And the last is provided by Section 14 is the provision against any intervention that a member of Congress may undertake before any governmental office for his pecuniary benefit. Now is the power of the Philippines Congress. The Philippines Congress is a legislative branch of the government. Its primary purpose in the lawmaking process. Generally speaking, legislative power is the power to enact, propose, amend, or repeal laws. The power to exercise the three inherent powers of the state is basically law making or legislation. The power of taxation is exercised by the legislature whenever tax laws will be passed, modified, or repealed. However, there are also some specific powers granted by Constitution of the Philippines Congress. Here are the list of the notable powers and functions of the Philippine Congress according to the mandate of the Constitution. These are plenary, power to propose amendment or revisions to the Constitution, power of appropriation, power of legislative investigation, power to question heads of departments, power to declare war, power to extend or revoke the suspension of the privilege of the writ of habeas corpus or the declaration by the President of martial law, power to confer amnesties granted by the President, power to confer treaties, power to confirm appointments, power to act as Board of Canvassers in presidential elections, and impeachment power. The plenary powers. Plenary power are actually the general legislative power of Congress. It involves Congress powers to enact, amend, repeal, and propose the laws to foster the common good of the people. This is the general lawmaking power of Congress. The lawmaking process. Article number 6 provide that law in Section 26 number 1. Bawat panukalang batas na ipinasa ng Kongreso ay dapat sumasaklaw sa isang paksa lamang na dapat ipahayag sa pamagat nito. Walang panukalang batas na ipinasa ng alinmang kapulungan ang magiging batas maliban kung ito ay makapasa ng 3 pagbasa sa magkahiwalay na araw at ang mga nakalimbag na kopya nito sa huling anyo ay ipamahagi sa mga miyembro sa loob ng 3 araw bago ito maipasa, maliban kung ang Pangulo ay nagpapatunay sa pangangailangan ng mabilisang pagsasabatas nito upang matugunan ang isang pampublikong kalamidad o emergency. Section number 7. Kung ang presidente ay inaprubahan ang nasabing batas, kailangan niya itong lagdaan, kung hindi man ay iveveto mo ito at ibabalik ito kasama ang kanyang pagtutol sa kabuuan sa journal nito at magpatuloy upang isaalang-alang ito. Ang Pangulo ay dapat magkaroon ng kapangyarihan na ireto ang anumang partikular na item sa isang appropriation, revenue o taripa bill, ngunit ang mas mahusay ay hindi makakaapekto sa item o sa mga bagay na hindi tinututulan. A statute is a law enacted by Congress. This has been pointed out in the previous reporters. Ang proseso ng paggawa ng batas ay isang nakakapagod at mahirap na proseso. Ito ay komplikado sa pagkakasangkot ng isang mahabang pamamaraan na maingat at kung minsay napakabigat. This is not because our Congress is not doing its job as we often hear from the news. The slow pace of law making is a product of constitutional rules that tends to outline the legislation. During the lawmaking process, statutes is not yet laws, they are just bills. Bills is a draft of a proposed law. Karaniwang binabalangkas ng proseso ng paggawa ng batas. Ang tanong kung paano magiging batas ang isang panukalang batas. Ito ay dapat pumasa sa lahat ng kinakailangan ng konstitusyon bago ito maging batas. Narito ang mga patakaran na related sa proseso ng paggawa ng batas. Ang panukalang batas na ipinasa ng Kongreso ay dapat maglaman ng isang paksa lamang na dapat ipahayag sa pamagat ng isang panukalang batas. Ang panukalang batas ay dapat dumaan sa mga pagbasa sa magkahiwalay na araw sa parehong kapulungan ng Kongreso. Ang mga nakalimbag na kopya ng final na anyo nito ay dapat ipamahagi sa mga miyembro 3 araw bago ito maipasa, maliban kung mayroong pambansang enehersya at ang Pangulo ang magpapatunay sa pangangailangan ng batas na agaran maipasa batas. Kung ang Pangulo ay makakarating sa isang partikular na bahagi ng panukalang batas, dapat niyang pagbutihin ang agwat. Kung hindi, iyon ay magiging isang invalid na veto. A bill will originated from a certain house which could be either the House of Representatives or just which is called the House of Origin. The member of the House of pandinig upang magbigay liwanag sa paksa. After the second reading, the open debate and argumentation will be open in the inter-membership of the House. Concert can fully participate. Ang panukalang batas pagkatapos ng pag-aproba nito sa ikalawang pagbasa nito ay hindi bababat sa 3 araw sa kalendaryo bago ang huling yugto nito ay dapat na maiprint sa huling anyo nito at ang mga kopya nito ay dapat ipamahagi sa bawat miyembro ng bahay. If the bill is approved after the 3rd reading, it will be transmitted to the other house for its approval. This bill will undergo the same tedious process undertaken in the House of Origin in the other house until it is approved thereby. Let's talk about the power of appropriation. The Constitution provides for the provision that shall outline this power. The Constitution provides that walang pera ang dapat bayaran mula sa kabangyaman maliban sa alinsunod sa isang laang gugulin na ginawa ng batas. Walang pampublikong pera o ari-arian ang dapat na angkop na ilapat na bayaran o nagtatrabaho ng direkta o hindi direkta para sa paggamit ng benepisyo o suporta ng anumang sekta, denominasyon ng simbahan ng sektarian na institusyon o sistema ng relihiyon o ng anumang guro na ministro, ibang relihiyosong guro o mga dignitaryo bilang ganoong pagtanggap ay itinalaga sa sandatahang lakas o alinmang institusyong penal o ampunan ng pamahalaan o leprosaryo. Lahat ng perang konektado sa anumang buwis ay nabubuhay para sa lahat ng layunin at ito ay dapat ituring bilang isang espesyal na pondo at babayaran iyon para lamang sa ganoong layunin lamang. Ang layunin kung saan ang isang espesyal na pondo ay nilikha at natupad o inabando na ang balanse kung mayroon man ay ililipat sa pangkalahatang pondo ng pamahalaan. The power of appropriation is a power of Congress to authorize the release and disbursement of public funds in the national treasury. Sometimes, this power called the power of purse. Ang kapangyarihang ito ay kinakailangan dahil walang disbursement ang pampublikong tungkulin ang dapat gawin maliban kung mayroong isang batas na nagpapahintulot dito. Now is the classification of appropriation law. It could be either general appropriation law. Ang batas na ito ay pinasa sa taunang batayan upang mabalangkas ang mga gastos ng pamahalaan sa loob na 1 taon ng pananalapi. The second one is Special Appropriation Law. Ang batas ay dinedesenyo upang marangkasin ang disbursement ng pampublikong pondo para sa isang espesyal o partikular na layunin na hindi kasama ang Pangkalahatang Appropriation Act. Limitation on the power of appropriation. New Constitution provides for the limitation of the power of appropriation. Maaaring hindi dagdagan ng Kongreso ang mga laang bubulin sa ipinag-uutos ng Pangulo para sa populasyon ng pamahalaan gaya ng tinutukoy sa budget. Ang form na nilalaman at paraan ng pagdiriwang ng budget ay dapat itakda. The lawmaking process. Article number 6 provide that law in Section 26 number 1. Bawat panukalang batas na
The power of legislative investigation. The Senate or the House of Representatives or any of its respective committees may conduct inquiries aid of legislation in accordance with its duty published rules of procedure. The right of persons appearing in or affected by such inquiries shall be respected. The Congress, kung saan sila ang tagapagawa ng batas ng gobyerno ng Pilipinas, ay may kapangyarihang mag-conduct o magsaliksik ng investigasyon sa tulong ng batas. Mayroong mga issue at kontrobersiya na kinakailangang imbestigahan muna ng Kongreso at pag-aralan upang matanggap at makapaglaan ng mabisang batas para sa nasabing issue. At sa pagkakataong ito na napag-usapan at napag-aralan ang nasabing issue, dito na maipapasok at maisasagawa ang batas na akibat na pangangailangan ng ating komunidad, lalo nating mga tao. Samantala, kung ang isang issue ay hindi napagbigay alam sa Kongreso, ang nasabing issue ay hindi mabibigyan ng pansin at walang batas na maisasagawa. In line with this power, Congress may function in a seeming fashion as that of a court of justice. This is not so. The power of Congress to conduct investigation or inquiry in aid of legislation may appear as a court hearing or trial, but in truth is only limited as to the solicitation of the truth of the matter regarding a particular controversy. Congress cannot pass judgment on the issues involved in the trial court. Bakit? Dahil iyon ay nasa jurisdiksyon ng hudikatura at kung ikaw ay lalabag sa prinsipyo, dito na ihahatol ang paghihiwalay ng kapangyarihan. Limitation on the power of legislative investigation. There is constitutional limitation on the power of legislative investigation. Number 1 is, it must be conducted in aid of legislation. Ang legislative inquiry, ito ay makapangyarihang kasangkapan ng Kongreso upang magampanan ng maayos ang tungkulin nito. Gayunpaman, maaari itong gamitin upang sirain ang reputasyon ng isang tao kung gagamitin ito ng hindi tama at arbitraryo. Ito ay nararapat na isagawa bilang tulong sa batas at hindi para lang sa anumang iba pang paraan tulad ng pampulitikang pang-api at pang-uusig. Number 2 is in accordance with duly published rules. Each House of Congress has their own House rules governing their everyday conduct of business, kasama na itong legislative inquiry. Ito dapat ay naaayon sa mga tuntunin sa konstitusyon na namamahala sa pagsasagawa ng pambatasan na pagsisiyasat. Ito dapat ay nailalathala ng nararapat kung hindi ito ay magresulta sa paglabag sa konstitusyon. Number 3 is rights of persons appearing in or affected by the investigation must be respected. Legislative inquiry must be conducted with utmost care and respect for the witness' civil constitutional rights. Nararapat nating igalang ang kahit na sinong witness sa isang naganap na issue. It's either mahirap man siya o mayaman. Hindi yung pag hindi siya nagsasalita ay hihiwan natin siya para magsalita siya. May mga pangyayaring ang mga saksi o witness ay nakaranas ng trauma dahil sa tindi ng isang pangyayari.
Kung maganap ang hindi tamang pagtrato sa isang witness, maaari itong magresulta sa isang hindi kasiya-siya at iligal na gawain. Incidental powers. As what I discussed above, the power of legislative investigation is somewhat akin to court proceeding. It can require the presence of witnesses and production of documents that can shed light to the issue at bar. Ang maayos na pagsasagawa ng batas ay kinakailangan din upang makuha ang ninanais na resulta. Kaugnay nito, the Senate and the House of Representatives, including their committees, can punish any contumacious witness with detention as long the session is ongoing. Maaari rin itong parusahan ng may tensyon ang sinumang hindi gumalang sa utos ng Kongreso. Sa ganitong paraan, ang Kongreso ay magagamit ng mahusay ang kapangyarihan ng legislative investigation. Power to question the heads of departments or the question are, the heads of departments may upon their own initiative with the consent of the President or upon the request of either House, as the rules of each House shall provide, appear before and be heard by such House on any matter pertaining to their department. Written question must be submitted to the President of the Senate or the Speaker of the House of Representatives at least 3 days before their schedule. Interpellation shall not be limited to written questions, but may cover matters related thereto. When the security of the state or the public interest so requires and the President so states in writing, the appearance shall be conducted in executive session. What is an impeachment trial? An impeachment is needed in order to remove an impeachable officer from office. It also serves as the preliminaries before a formal complaint is filed before a court of justice or the Sandigan Bayan. Ang impeachment ay formal na tinukoy bilang isang pambansang pagsisiyasat sa pag-uugali ng isang tao. It is one of the mechanism of checks and balances kung saan susuriin ng Kongreso ng Pilipinas ang kapangyarihan ng iba pang sangay ng gobyerno kabilang ang mga komisyoner ng Komisyong Konstitusyonal. The impeachable officers are the government officials that enjoy security of tenure during their term and can only be removed through impeachment.